Prior to the issuance of the consultation paper by the MES proposing a new regulatory framework for equity-based crowdfunding, there was a lack of regulatory clarity on how the regulators would look at an equity-based crowdfunding platform. When one looks at regulatory issues in relation to crowdfunding, there are two basic dimensions, the first being licensing and the second being whether the prospectus regime applies in terms of offer of securities. In relation to the first issue on licensing, we have a regime in Singapore where dealing in securities is drafted in a very wide manner. It captures both direct and indirect solicitation of securities. And therefore, equities-based crowdfunding platforms which operate without a license could run the risk of having a regulatory breach, and that depends on how they are structured. Turning to the second dimension, which is the issue of whether prospectuses apply. Well, generally, you need a prospectus when there is general offer of securities. There are some exemptions that could apply in relation to small offers below a certain amount or private placements where you offer it to a defined group of offerees, or there are some carve-outs for offers to institutional investor or accredited investors. Again, this may or may not apply depending on how the crowdfunding platform is being structured. Now, so the MES has come in and given some regulatory clarity. It now says that equities-based crowdfunding platform will be treated as dealing in securities as an intermediary. They'll be regulated under the Securities and Futures Act. The MES has reduced some of the regulatory capital requirements and some of the other requirements which might seem onerous, subject to certain provisos. The MES is of course concerned, so as a regulator, in looking at investor protection issues for equities-based crowdfunding platform. In fact, the MES identified 4 specific risks in relation to equities crowdfunding. The first being a loss of capital for investors. Well, there are inherent risks when you place monies and that's being invested in a startup. Some people have likened it to buying a lottery ticket. Second is lack of liquidity. There is no secondary market, so it might be difficult for investors to on-sell their stocks to cut losses. Third is a risk of fraud because there is no personal contact between the investors and the investees. One worries whether there's sufficient disclosure of information. There's an asymmetry of information, essentially. The last concern in terms of investor protection issue is if the platform should close in light of failure of the crowdfunding platform, what happens to the customer monies? The concern is that if you don't have rules requiring segregation of monies belonging to investors, they might lose their money. And creditors of the crowdfunding platform could have access to this if there's no proper ring fencing of assets.